life, religious liberty, and family, we have come to an end of the today's part of the conference. And within this panel, we are going to have Johanna Fröhlich as a moderator, and she's a senior research fellow at the Research Institute for Politics and Government at Ludoviko University for Public Service. Within this panel, firstly, we are going to hear online Professor John Keown, who is the Rose F. Kennedy Professor of Christian Ethics at the Kennedy Institute of Ethics at Georgetown University. And we are also going to listen to Stephanie Barclay, also from Georgetown University, where she is a professor of law and also she's also a faculty co-director of the Georgetown Center of the Constitution. So thank you very much, and let us listen to them. Thank you.
Professor Keown, the floor and screen and microphone is yours.
Thank you. Can you hear me all right? Can you hear me?
Yes, you can. Yes, we can.
Thank you. Well, I will start by thanking the organisers for inviting me. Sorry I can't be there in person. I would dearly love to be there in person. My title was a placeholder title, The Sanctity of Life and the Criminal Law. It's since developed into a slightly longer title, Judges, Inequality and Dignity and the Withdrawal of Life-Sustaining Treatment from Dying or Disabled Infants. Now, I've got a very long paper, so I'm just going to give you the edited highlights because I only have, I believe, 15 minutes, so I'll have to be quite brief. I'm grateful to Professor Tollefson, who kindly let me have a view of his paper, and as you'll see when he gives his, there is a nice dovetailing between our two presentations. Let me start. So in 2017, the Charlie Gard case attracted worldwide attention. Charlie was a terminally ill infant who had suffered progressive brain damage and muscle weakness from a rare genetic condition. He was kept alive on a ventilator in the Great Ormond Street Hospital for Sick Children in London, the renowned paediatric hospital. His doctors wished to withdraw his ventilator on the ground that his condition was hopeless. Charlie's parents disagreed. They wanted to fly Charlie to New York, where a doctor was willing to treat him with an experimental drug, which offered the possibility, however remote, of preventing further deterioration in his condition. Their wish to continue the ventilation and seek treatment elsewhere was supported by many people who witnessed the plight of Charlie and his parents through the media, including President Trump and Pope Francis. The hospital, however, had Charlie made a ward of court and asked the judge to hold that Charlie's best interests required disconnection from the ventilator. The judge, after hearing from lawyers for the hospital, for Charlie's parents, and for the legal guardian who had been appointed to represent Charlie's interests, agreed and granted the declaration. And the parents' appeals to the Court of Appeal, the Supreme Court, and the European Court of Human Rights were dismissed. So Charlie's case raised at least two important ethical questions. First, to what extent should parents, rather than doctors or judges, have the right to decide whether treatment in such cases be discontinued? Second, to what extent have the English courts, in holding that a treatment is not in the best interest of a sick infant, adopted the controversial ethical view that their lives are of no benefit? This paper explores the second question, though the answer to the second has implications for the answer to the first. The paper maintains that the courts have indeed adopted the view that the lives of certain children lack benefit, and wrongly so. The paper comprises three parts. The first part outlines the ethical view that all children, whatever their age, disability, and life expectancy, enjoy an equal and intrinsic dignity. It points out that their equality and dignity is recognised by English law in its prohibition on the intentional shortening of their lives, as well as by international documents on human rights, that prohibit discrimination on the ground of disability. The second part of the paper notes that in the Charlie Gard case, and in a similar line of cases both prior and subsequent to it, the English courts have rejected the equality in dignity of these sick children by judging that their lives are of no benefit or even a disbenefit, which judgment is thought to justify or help justify the discontinuation of their life-sustaining treatment. Part 3 of the paper comprises a brief conclusion and notes that a proposal to amend the law, called Charlie's Law, does not go far enough to ensure respect for the equal dignity of all infants or for their parents' rights. So briefly, a summary of part 1 on the equality and dignity of all children. The view that disability can be such as to deprive an infant's life of benefit and of their equality and dignity with non-disabled infants is inconsistent with the doctrine and principle of the sanctity or inviolability of life that lies at the heart of natural law ethics and that has long underpinned English law. The sanctity of life is indeed regularly cited in cases like Charlie Gard by counsel, medical witnesses and judges as a key moral principle, but it is far more often cited than it is understood. The principle, which has historically shaped the criminal law's prohibition on intentional killing, reflects the moral view that the life of every patient, however sick, disabled or close to death, has an intrinsic, ineliminable worth and dignity. And it's because of that dignity that it's always been and remains a serious crime for a doctor intentionally to administer a lethal injection to any patient, even if the patient's seriously disabled and suffering, even if the patient is on the cusp of death, and even if the patient requests a hastened death. That absolute legal prohibition reflects the view that we all enjoy an ineliminable dignity in view of our common humanity, a dignity that grounds our right to life, our right not to be intentionally killed. Needless to say, that principle is not vitalist. It does not hold that human life is a supreme moral value to be preserved at all costs. Both the law and traditional professional ethics have long recognized it's proper to withdraw extraordinary or disproportionate treatments. And they may be disproportionate either because they are futile or too burdensome to the patient. Futility permits, though it doesn't necessarily require, a patient or a parent to refuse a treatment. But there is clearly a crucial moral distinction between withdrawing a treatment because it's futile and withdrawing a treatment because it's thought the patient's life is futile. The latter judgment is inconsistent with respect for the patient's dignity. All patients have a right not to have their treatment withdrawn because a doctor or a judge thinks their lives are of no benefit or lack dignity, especially if the treatment is withdrawn with intent to hasten their demise. This distinction was clearly explained by Lord Justice Ward, the presiding judge in the famous conjoined twins case. In that case, his lordship affirmed, "What the sanctity of life doctrine compels me to accept is that each life has inherent value in itself, and the right to life, being universal, is equal for all of us." He said, "Given the international conventions protecting the right to life, I conclude that it is impermissible to deny that every life has an equal inherent value. Life is worthwhile in itself, whatever the diminution in one's capacity to enjoy it, and however gravely impaired some of one's vital functions of speech, deliberation, and choice may be." In another case, the Lord Chief Justice, affirming the conviction of a mother for murdering her son, who was in a persistent vegetative state, said that in the eyes of the law against intentional killing, a disabled life, even a life lived at the extremes of disability, is not one jot less precious than the life of an able-bodied person. And also in this section, I then go on to quote various international documents of human rights, which reinforce that fundamental notion of equality in dignity. For example, the UN Convention on the Rights of People with Disabilities, which came into force in 2008, and whose preamble recalls the Human Rights Convention's affirmation that everyone is entitled to all of the rights and freedoms it sets out without any distinction of any kind. The preamble also holds that discrimination on the basis of disability is a violation of the dignity and inherent worth of the human person, and notes that children with disabilities should have full enjoyment of all fundamental rights and freedoms on an equal basis with other children. We may now contrast that idea of fundamental equality and dignity that undergirds the prohibition on murder and those international documents on human rights with the reasoning of the courts in cases like Charlie Gard. So this brings us now on to the second part of the paper. Now, this paper discusses half a dozen cases, so I'm just going to focus on one or two highlights from one or two of the important decisions. In the Charlie Gard case, as we've heard, the judge decided it was in Charlie's best interests to have his ventilation withdrawn and for him to be given palliative care only up to his death. The judge, in coming to this conclusion, said the law was clear, that in determining the child's welfare, that was the court's paramount consideration. The judge quoted the preceding legal authorities. He said the judge must decide what's in the child's best interest. The welfare of the child is paramount, and the judge must look at the question from the assumed point of view of the child. Though there was a strong presumption in favour of prolonging life, that presumption was not irrebuttable. Considerable weight must be attached to the prolongation of life. That could be outweighed, said the judge, if the pleasures and the quality of life are sufficiently small and the pain or suffering and other burdens of life are sufficiently great. The court, he said, should listen to the parents as well as the views of the doctors, but the parents' views were wholly irrelevant to consideration of the objective best interests of the child. He granted the declaration that the ventilation should be removed. The parents appealed to the Court of Appeal, to the Supreme Court, and to the European Court of Human Rights, but without success. What I'll simply do here is to point out the extent to which the submissions of counsel in the Charlie Gard case and the reasoning of the judges really discloses their view that the lives of certain disabled children are either of no benefit or are a disbenefit. In the Court of Appeal, counsel for the hospital that was seeking withdrawal of ventilation said that Charlie suffered significant harm from being ventilated, and that harm she described as a condition of existence of which is offering the child no benefit. Well, that clearly identifies the harm, not in terms of the suffering imposed by the treatment, but in terms of the life that the treatment was maintaining. We'll also recall that the judge said that the presumption in favour of life could be outweighed if the pleasures and quality of life are sufficiently small and the pain and suffering of other burdens of living sufficiently great. That clearly relates to the perceived value of the child's life, not to the benefits and burdens of the treatment. And in the Court of Appeal, the presiding judge, endorsing the trial judge's finding that taking Charlie to the United States for experimental therapy would not be in his best interest, said that such a course would, quote, simply prolong the awful existence that the judge found was the current state of Charlie's life. So the words awful existence clearly disclose that Charlie's life was not only thought to be of no benefit, but was an actual harm. Unless it be thought that the judge's words were merely infelicitous, there is other evidence that the courts in these cases are engaged in precisely that form of judgment. The evidence takes the form of their repeated reliance on guidelines on withdrawal of treatment issued by the Royal College of Paediatrics and Child Health. That guidance, which is regularly cited, clearly holds that the lives of some disabled children are either of no benefit or are actually a burden. For example, in the relevant part of the guidance states that the child's condition can involve burdens that outweigh the benefits of the child's life. And the third category specified states that the child's condition can make it impossible for the child to derive benefit from their life. So these are clearly judgments which deny the fundamental equality and dignity of children with these serious disabilities. And Charlie Gard wasn't by any means the first case. There are previous cases in which judges had held that the lives of certain children are essentially not worth living. One can cite a case that goes back to 1981, a Down syndrome child who needed a simple surgical operation to remove an intestinal blockage. The court in that case authorized the removal of the blockage as being in the child's best interest, but the judges said there might be other cases where they would not have so held. There might be cases where the life of the child is going to be demonstrably so awful that it should be condemned to die, said one of the judges, or where the child's life was likely to be intolerable in the view of the other judge. And other cases before Charlie Gard could be cited. Similarly, cases after the Gard case, such as the case of Alfie Evans, the very year following, similar kind of fact situation, in which the judge overruled the parents and held that Alfie Evans's ventilation should be withdrawn. What's interesting in this case is that the judge held that discontinuance was in Alfie's best interest because treatment compromised his future dignity and failed to respect his autonomy. This is doubly problematic, of course, because not only did Alfie, or would he never have lost his intrinsic dignity, but he had no autonomy at all to be respected. The judge in that case very strangely cited an open letter from Pope Francis in support of his decision, which had been tendered by counsel for the hospital, that there is no obligation to have recourse in all circumstances to every possible remedy, and that it was proper to withhold disproportionate measures. And the judge said the Pope's letter was a comprehensive answer to the expert of a medical witness from Germany. This Germany, who was a pediatrician at a hospital in Munich, had supported continued ventilation of Alfie in this case, and his removal to another hospital that was willing to continue his ventilation. The German expert added that because of the historical experience of his country, Germans had learned there were certain ways you should not treat severely disabled children. He said a society must be prepared to look after these severely handicapped children and not to decide that life support has to be withdrawn against the will of the parents if there is uncertainty of the feelings of the child, as in this case. The judge's response to this German expert's testimony was to criticize it as inflammatory and inappropriate, on the ground that the expert's views bore no relationship to the facts of the case, and it was no part of the expert's function to utilize the case as a platform for his own personal views. But it's not easy to see why the judge criticized the German expert's testimony as either inflammatory or inappropriate. Moreover, it's clear that both counsel for the hospital and the judge fundamentally misunderstood Pope Francis's letter, which they thought provided a rebuttal to the expert's opinion. Catholic moral teaching agrees with the expert's testimony that all infants, irrespective of disability, enjoy an intrinsic dignity, and that it's wrong to withhold or withdraw treatment on the basis of a judgment that their life is awful. Second, while the church teaching holds there is no obligation to apply disproportionate treatments, it doesn't hold it's therefore wrong to maintain them. It draws a distinction between a treatment being morally obligatory and a treatment being morally optional. So in short, the papal teaching cited by the judge does nothing to support his judgment in that case or the judgment in Charlie Gard's case. On the contrary, the papal teaching is inconsistent with the judgment in those cases and with the guidance of the Royal College of Pediatrics, which openly asserts, contrary to Catholic moral teaching, that the lives of some infants with disabilities are of no benefit or a burden. And finally, in fact, Pope Francis himself lent his personal support to Alfie Evans's parents and asked that their desire to seek new forms of treatment may be granted. He instructed the Vatican Secretary of State to seek a diplomatic solution, facilitated by the grant of Italian citizenship to Alfie by the government, and arranged for the president of the Bambino Gesù Hospital to fly to England to try and persuade the English doctors to allow Alfie to be flown to Rome on an Italian military helicopter. After Alfie's death, the Vatican Secretary of State, Cardinal Parolin, said that he could not understand the English court's refusal to allow Alfie to be transferred, and he referred to the stubbornness of the English judges. despite the Pope's appeal. Unfortunately, as in the Guard case, appeals to the Court of Appeal, the Supreme Court, and the European Court failed. And the final section of the paper are brief conclusions, which I can keep even briefer. So the problem in these cases is not that the courts are making decisions that are fundamentally moral, but the moral decisions they are making and the way they're making them are vulnerable to serious criticism, mainly because they adopt the controversial view that the lives of some disabled children are either of no benefit or are a burden. That view is contrary both to the foundational moral and legal principle of the sanctity of life that holds that all patients are equal in dignity, and, it seems to me, to international human rights documents that reject discrimination on the grounds of disability, not least when that disability results in the death of the patient. Unfortunately, the court's understanding of key ethical concepts, including the sanctity of life, dignity, and equality, is opaque. They often say the sanctity of life means different things to different people, and so it does. But the courts need to give it an objective meaning in law, and in law its meaning should be, as Lord Justice Ward observed in the conjoined twins case, that all human lives, irrespective of disability or projected lifespan, and enjoy an equal and inalienable dignity and a right not to be intentionally killed or abandoned. They also refer to dignity as a problematic and subjective concept, but it's not. Dignity, properly understood, is an objective and central moral concept, as reflected in the preamble to the UN Human Declaration, where it's regarded as the basis of human rights. In that sense, it's the very foundation of human rights, however diverse, multicultural, and multi-faith a society may be. And it's remarkable that the courts have consistently declined to recognize and affirm the important role that this understanding of dignity should play. So thank you. I'll end there and pass on to my distinguished colleague, Professor Stephanie Barclay.
It's a treat to be here with you all this afternoon. Thank you to the organizers. It's especially a treat to be on the same panel with Professor John Keown, my favorite Georgetown colleague. So wonderful to see him. It's not so great to be the follow-up act to Professor John Keown and John Finnis and be in the unenviable position of what stands between you and a fascinating tour of the Basilica. So I will try and keep my remarks brief, but I'm really grateful to be here. I'm going to touch on three elements in my remarks. One is the importance of religious liberty. The second is a debate about how we ought to protect religious liberty and what role the judiciary specifically should have in the protection of that right. And then third, I'm going to touch on some ways in which those questions informed by natural law have been brought to bear in the United States and the real world, as is the topic of this excellent conference, in a few different contexts. So to begin with, the importance of religious liberty is something that a number of scholars have discussed from the natural law tradition. Professor Finnis maintains in Natural Law, Natural Rights that the basic human good of religion consists fundamentally in bringing our lives in harmony with the divine, or to establish and maintain proper relationship between oneself and the divine. This irreducible, distinct human activity can be understood and affirmed as valuable without any prior or accompanying commitment to belief in God. As Finnis writes, if there is a transcendent origin to the universal order of things and of human freedom and reason, then one's life and actions are in fundamental disorder if they are not brought, as best as one can, into some sort of harmony with whatever can be known or surmised about that transcendent order and that lasting order. So there are correct answers to what that transcendent order looks like and what it would mean for us to bring our lives in harmony with that transcendent order. Why then would we protect a legal right for people to get it wrong on those answers, to identify orders of their life that would not in fact bring their life in order with that transcendent order? Robbie George has written about ways in which Aquinas may not have given sufficient attention to the need to give people space to get it wrong, to really be able to choose virtue on that fundamentally important human question. So Professor Finnis has written that when conscientious objection witnesses to basic values such as life or religion are not radically incompatible with the genuine common good, it may be tolerated, notwithstanding the conscientious judgments of rulers, that laws that are objected to are really necessary. Gerald Bradley has built on some of this work by Finis and offered a few reasons for why we ought to do more than just tolerate religious liberty, but in fact have robust protections for religious liberty. His first argument is that in accordance with beings endowed with reason and free will and therefore privileged to bear personal responsibility to that, all men should be at once impelled by their nature and also under a moral obligation to seek truth, especially religious truth. And so in this way, religious liberty is comprised of two moral duties that each person is obliged to seek, and to affirm truth as one seeks it, and then to live in accordance with that truth that one affirms. But men can't discharge these obligations in a manner keeping with their own nature unless they enjoy some realm of immunity from external pressures or coercion with respect to the decisions that they might make as they seek that truth. The other point that Gerald Bradley makes is that religious liberty is also a moral duty in each of us to provide for that space for others to seek that truth wherever that takes them, within some limits that I'll discuss later. A second argument that Gerald Bradley makes is that governments stand in an asymmetrical position when it comes to religious liberty. Government has great power to lead people astray when it comes to pursuit of correct principles with respect to religion. Governments are much more limited when it comes to their ability to lead people correctly when it comes to their pursuit of truth on principles of religion. And that might be a reason why we ought to be skeptical or cautious in endowing governments with too much power with respect to that pursuit of truth that they can and often have abused in ways that, in fact, might take people away from the correct answers on those questions. And then a third answer, or a third reason that I'll offer is one that is influenced by Sean Coyle's recent excellent work on natural law and natural rights, and that is his work on natural law, and that is his explanation of the difficulty of attaining a correct understanding of the good or goodness. He explains the considerable difficulty that is inherent in that pursuit. That doesn't mean, obviously, that the good isn't knowable just because it's not known, any more than mathematics are not knowable just because many people don't know them. But one thing Sean talks about is ways in which we can know of goodness by sort of bringing our actions in line with principles, a working hypothesis, if you will, and then seeing what the fruits are of those labors. It reminds me of John 7:16-18. If any man will do his will, he shall know of the doctrine, whether it be of God or whether I speak of myself, end quote. And religious liberty makes room for people to have the space to experiment in their pursuit of identifying what is the good, which means that they need room to make mistakes along the way. So religious liberty is grounded in this need for humans based on their nature to pursue truth about good, to be free from undue influence of others, that is meant to provide space needed to be the author of their own religious convictions, to own them, to make mistakes about them, to bring their life in order with them. So how do we protect religious liberty as a constitutional or a human right? Is there a role for the judiciary to play in the protection of that important natural right? In Legislated Rights, an important book I recommend to you, Gregoire Weber, Paul Yao, Richard Eakins, Maris Kopke, Bradley Miller, and Francisco Urbina rightly draw attention to the ways in which the political branches have a critical role in protecting our rights, and the problematic sort of received view or received wisdom that it's up to the judiciary to protect rights and that political branches should basically govern as much as possible and run roughshod over rights until the judiciary stops them and is the brakes in the system. I think that that's correct, and I think that that's an important point. But one argument that they also make that I will maybe draw a distinction with is that basically it should primarily and maybe almost exclusively be up to the political branches to decide how much to delimit or how to define rights, which I think would leave no real role for the judiciary in that process. Now, it may be the case, and Finis touched on this earlier, that in some constitutional systems it might not make sense to have the judiciary be involved in robust ways or in a protection of a Bill of Rights. Britain doesn't have a Bill of Rights, and there might be important reasons why a constitutional system decides not to adopt one. But for constitutional systems like the United States, like Canada, that have adopted a Bill of Rights, is there a way to protect those constitutional rights, especially the constitutional right to religious exercise, in ways that are consistent with the natural law approach, in ways that don't cause undue tension between the judiciary and the democratically enacted authorities, in ways in which the judiciary might sort of follow some of the problems that Finnis was discussing earlier with the living tree approach, where then we're divorced from authority in those constitutional systems. This is an argument that I take up in my forthcoming article, Constitutional Rights as Protected Reasons. And in this article, I argue that constitutional rights should be understood as a protected reason in the sense that Raz talks about. So they are first-order reasons why political branches might choose to give a special weight to protection of constitutional rights, why those political branches might, for example, think that this right is a particularly important aspect of the common good of that society, but they also exclude certain reasons why we might limit those rights. In a way, when a society chooses to memorialize a right, I think what you can understand the society doing in a way that's consistent with a common good approach is it's sort of a legal heuristic. They are saying, this particular human activity, pursuit of religious exercise, we think is so central to the common good that we want to take certain reasons off the table as a justification for interfering with this particular type of activity. In part because we have seen in the course of human history that when government is making snap decisions about it, and they're allowed to use any reason to justify interfering with this particular type of human activity, that they will often get it wrong. And in that way, by memorializing constitutional rights, we are trying to limit the scope of reasoning that political branches can do when it comes to some of these important rights and ensure that some justifications remain off the table. So when it comes to religious exercise in the United States, for example, the way in which I think this protected reason approach operates is, first of all, the judiciary is competent to decide whether or not there is in fact a conflict between whatever permissible justification government might offer. Say we need to limit religious exercise in order to protect human life, and the type of religious exercise at issue. In order to override a reason, they must be in conflict. And I think the judiciary can ask that question. Are these things in conflict here, or is there a way to accomplish both? And then the second question that I think that the judiciary is competent to ask is whether or not the reason that the government has offered is one of these sorts of justifications or reasons that has been excluded or not. That's all pretty abstract. Let me break that down for you in terms of how I think that has played out, can play out in two real cases in the United States. And let's assume for the sake of discussion that the right to religious exercise includes within it the important limitation that you cannot exercise your religion when that would threaten human life. Another fundamental human good, and so consistent with the natural law approach, your religious exercise cannot extend to do that, and the law recognizes that. And so if government is limiting your religious exercise to protect someone's human life, that's a permissible reason, that's a non-excluded reason why government might limit your religious exercise. One context in which this came up is one that Professor Finnis discussed in his remarks was during the COVID-19 pandemic, there were a lot of new restrictions that were placed on religious groups and religious worship, and the justification given was, of course, protection of human life. And so what the judiciary was litigating or evaluating in those cases, I think, was not the question of what's more important, religious liberty or human lives, in a way that pits constitutional rights against the common good in a way that I think is antithetical to the natural law approach. The judiciary was asking an evidentiary question, is it in fact true that we cannot both protect human lives in this context and allow religious individuals to gather and worship? So for example, in New York, where restrictions were placed only in certain neighborhoods that prevented people from gathering, no matter how big the building or cathedral was, huge, massive cathedral can only have 10 people in it for religious worship, or a huge Jewish synagogue. Is it really the case that that sort of restriction is necessary to protect human rights? The court was skeptical because it just so happened that the neighborhoods that the government was targeting were ones that had heavy Orthodox Jewish populations. And the government, when they drafted this policy, held up a photo of an Orthodox Jewish funeral and said, this is the problem that we're trying to solve with these regulations. And the court said, if in fact these regulations are necessary to protect human life, we would assume that they would be implemented uniformly everywhere and not just in these particular neighborhoods. And so here, government, you have failed to carry the burden that there is a conflict between religious exercise and human life in this context. Now let me offer another context where I think the conflict isn't hard at all, and that is a case that is being litigated in Indiana right now, where the Court of Appeals has ruled that certain groups, including different Jewish groups, have a religious right to seek an exemption from abortion laws. So in Indiana, in the wake of Dobbs, that state passed a law that would limit abortions with only certain exceptions, things related to the health of the mother and some other pretty narrow considerations. And so these groups were arguing, my religious exercise, which compels me to seek an abortion, entitles me to receive an exemption from this law. This law cannot be enforced against me if I wish to seek an abortion. This is a context where I think the conflict between religious exercise and the government's non-excluded permissible reason in protecting human life is apparent. There is no way for the government to advance its interest in protecting individual lives that it has defined as being starting from the moment of conception and to accommodate the woman's religious exercise request in that case. And it's a reason that I'm hopeful that the Supreme Court in Indiana will overturn the Court of Appeals decision, and we'll see that decision is still pending right now. So these are some of the ways in which I think focusing the questions on, is there in fact a conflict, or could we have essentially what is a Pareto efficient outcome here where we can protect people's religious exercise in ways that do not interfere with other fundamental human goods, such that the common good of the entire community is promoted? That's the question that we can ask. That's the question I think that the judiciary is more effectively focused on, in a way in which when we view these conflicts through that lens, we're no longer pitting things like religious liberty against the common good, but integrating it within the common good. Thank you.
And I think we have around 15 minutes for questions, if there is any. Or we could leave earlier to the Basilica. That's an option. Please, Paul.
A question for Stephanie. I'm just wondering if you would distinguish, when you talk about excluding certain types of reasons that legislatures act on, from motivations. And I'm thinking of the animus jurisprudence of the Supreme Court, which looks for this idea of kind of sheer contempt or hostility. Yeah, that's my question.
Yeah, it's a great question, because obviously, especially in non-legal philosophy circles, when you hear the word reason, what comes to mind is a subjective motivation, and that's not what I'm most interested in. So David Enoch has laid out 3 different types of reasoning that might be relevant for practical reasoning, but I think that also map well into constitutional law. One might be the subjective motivation that is the relevant reason why someone acted. One might be the actual stated motivation, so whatever someone says they're acting for, which may not in fact be their real subjective motivation. And a third reason, the one that I think is most important, is a normative reason. So regardless of what motivated someone or what they said, is there in fact just a state of affairs, facts in the world that provide a normative justification for doing this thing? So I think that doctrines like strict scrutiny are most effective when they are not trying to probe the subjective motivations of government. They're trying to analyze, is there in fact a normative reason such that whatever they said their reason is true? And so in the COVID cases, government says that it must restrict people from gathering more than 10 people in a huge synagogue or cathedral. Is that a fact about the world that in fact provides a normative justification to protect human life, to restrict religious exercise? We think not. We think that the government didn't carry its burden there. So I think normative reasons are the most important type of reasons to consider under the exclusionary reason approach.
Connor, and then Pierre.
So one question, if I can steal 2 questions, if that's okay, I'll be very quick. So if one question's for John, which is if the legal reasoning of judges continues in this vein, such that artificial reason of law becomes separated from genuine practical reasoning. Is there an argument for saying that judges shouldn't be making these kind of decisions? You know, just like we have special tribunals for employment and welfare, perhaps these are just decisions judges as lawyers are increasingly ill-equipped to decide, you know, best interest and things like that. I don't know what that tribunal could look like. Ideally, it would be staffed with Dominicans or something, but it might be unlikely. And for Stephanie, it's kind of an originalist question, or a question about the original understanding of the Establishment Clause, because I've heard the position that that only applies to the federal government, such that there would be nothing preventing a state government from confessing the truth of a particular, bearing witness to the truth of a particular faith. Which I think, just to say my cards on the table, I think that is entirely consistent with natural law, provided that rights of conscience are tolerated as long as they don't disturb public welfare. But just as a historical question, if you have any opinion on that.
Professor Keown?
Thanks, Conor, for your question. Can you hear me all right?
Yes, we can hear you.
I don't think there's anything wrong with judges making these decisions, and I don't think much would be gained by having a different forum, some kind of tribunal, because that might be staffed by lawyers or others who still get it wrong. You know, I don't think there's any benefit necessarily to opting for some kind of tribunal rather than a court. I think the problem is just that the judges are getting it wrong. Not all of them, of course, because as I quoted some who were absolutely right that disability should not make any difference to the way someone's treated. So I think it's a question of trying to persuade the judges and the lawyers who appear before them of the inaccuracy, the erroneous kind of arguments that are fundamentally discriminatory. You know, I think they just don't stack up. And I think, you know, what we need to do is to persuade them of that and make sure they get back on the right track.
Conor, let me answer your question both from sort of a natural law point of view and then a historical originalist U.S. point of view. When it comes to a natural law argument, I agree with you that it is consistent with natural law for a government to say, we think this is true, but we're going to allow for there to be room for dissenters. I think that that's a perfectly fine approach for a government to take. In the United States, it's interesting because Judd Campbell has an article forthcoming in the Harvard Law Review where he argues some of our constitutional rights that were listed in state and federal constitutions were declaratory in the sense that they were just meant to be a placeholder for this other natural right that they believe existed and had content independent of the text. And then there are some constitutional protections that really came into being only because of the text. And those rights, Judd says, are specified, and the first ones are declared. I think that the Establishment Clause, to the extent we even define it as a right, is best understood as a right that is specified. So only given life through the text of the federal Constitution and not a natural right to non-establishment. And so if it weren't for the 14th Amendment, that limitation would only apply against the federal government. There have been arguments made by some scholars that with the incorporation doctrine that was birthed under the 14th Amendment, that the relevant originalist time period is to look at how people viewed establishment around the Reconstruction era, not the founding era. And by the time of Reconstruction, people viewed establishment more natural right-ish or individual right-ish, and therefore it is appropriately incorporated against all state governments. I don't think that's a very strong historical argument, but it is how we now live in the world we live in today, essentially in the United States, where the Establishment Clause has been interpreted to apply to all governments in our country.
Thank you. Pierre.
Thank you. So, Stephanie, I was wondering with the way you presented the idea of rights as protected reasons, as exclusion for other reasons for actions, policy. In the way you presented them, it sounded as if you were avoiding this idea of weighing principles or the proportionality test. I wonder if you can say a little bit more about that, because it's really interesting.
You're exactly right that my approach is meant to avoid weighing of the value of different competing interests. I mean, Connor and Adrian Vermeulen have written about, and Sean has as well, the problem of pitting rights against the common good. And I think sort of a paradigm view of the judiciary that that's their job, is to weigh these competing things, is problematic from that point of view, is not integrating rights within the common good. It's also problematic because a lot of these values are incommensurable. And so there is no rational answer to the question, what's more important, this person's religious exercise or this human life? So I think asking the judiciary to answer that question is basically telling the judiciary, pick whatever subjective outcome you like in this case, which leaves us at the very least with a democratic deficit and a lot of other problems of rationality. Raz's approach to exclusionary reasons is meant to avoid the problem of weighing. Some reasons are off the table. We're not weighing them. They just don't get to go on the scales. And I think the approach I'm offering for constitutional rights is meant to sort of obtain those sorts of benefits from the exclusionary reason approach.
Any more questions? We still have time, perhaps. Yes, Armando.
Thank you very much for your presentations. My question is for Professor Keown. So regarding the Charlie Gard's, Alfie Evans's, and Indy Gregory's cases, I was wondering, in your opinion, would it be possible to claim that they were not cases in which their dignity was violated, but they were cases of dystonasia? So I don't know what's your opinion about that. Thank you.
Thank you. Professor Keown.
Well, of course, euthanasia would connote the intentional hastening of their death. And I don't think that necessarily was the case, because I think when one withdraws treatment because one thinks the life isn't worth living, one might be doing it with intent to shorten life, but not necessarily doing it with intent to shorten life. So I wouldn't want to say they were cases of euthanasia, but they are clearly rather close to, even if they didn't involve an intention to shorten life, it's just a hop, skip and a jump towards euthanasia, because if the courts are saying that you may withdraw treatment because this life is of no benefit or is a burden, then why not intentionally end it? Why not certainly hasten the end? Why allow the child to linger? So the courts are not only disrespecting the dignity of these children by reasoning that they're not worth preserving, but they are inviting a change in the law so that it allows the intentional termination of these children, either by withdrawing treatment or tube feeding, or by a deliberate act. And I don't think the judges see this. I don't think they're fully conscious that this is what they're actually engaged in. And that's why these decisions are so dangerous and need to be looked at again. And the courts need to return to the principle that Lord Justice Ward defended in the conjoined twins case, the fundamental equality and dignity of all patients, while recognising that, not all treatments are obligatory, and in many of these cases it's perfectly proper for parents to withdraw treatment, but not on the ground that the child's life is not worth living.
Thank you very much. We have 5 more minutes. If there's any more last question, Veronica, please.
Well, thank you, Stephanie. I read your paper on constitutional rights as exclusionary reasons. So I think we had this discussion, but now I have more clarity on what you're trying to say. And I don't know. I don't think that the exclusionary reasons will do the work you want to do, because you want to say that precisely this right is so important, is embedded in common good, so it's fully content, it's full of content, right? So it can be, so the judge needs in a way to engage with his right, with the nature of the right and the content of the right. So of course, what you want is that certain other reasons are excluded, but you don't need exclusionary reason. Wouldn't say because the content of this right is so important, it's a basic good, and it's connected to the common good, that's why it ought to be considered. I don't know if I'm explaining.
Well, so you're right that I think that a judge would have to engage with the question of, is the content of the right really triggered at all in a way that you might think of it as a prima facie right, is something I refer to in my piece. Before we even look at exclusionary reasons, which I think is rigorous analysis, we don't need to look at that if the content of the right isn't triggered at all. So that's work that any constitutional system that thinks the judge has a role in protecting rights requires judges to do. That's the first step of the analysis. My proposed exclusionary reason doesn't add to or take away from the fact that judges need to ask that question. I would say separately, I think judges ought to be pretty constrained by the original settlement of what the content of that right was meant to look like when it was memorialized in the Constitution textually and based on what history tells us about the content of that right, and not read it really expansively for some of the reasons that John discussed earlier, because then we're getting away from the settlement in terms of why we would have wanted to memorialize that right as part of the common good anyway. But what my approach does add is that there's still this received wisdom that after judges take that step and have decided that we have a prima facie constitutional right, or we've triggered this sort of analysis, then what the judge is asked to do at some stage of the analysis, either under strict scrutiny or proportionality, is decide which is more important, that right or the government interest. And that is the analysis that I think is irrational, that also then is pitting the idea of the autonomous individual rights against the broader common good. And I think that's the part that's conceptually problematic. And so what we're doing when we're memorializing rights is we're saying that this interest is important enough that we're going to exclude some reasons for interfering with it. And you could think of it as the more important people view a right to the common good, the more reasons that they might exclude. Some rights do become categorical, like the right against torture. Raz talks about how some exclusionary reasons exclude all reasons, and there are no reasons that we would allow torture in some constitutional systems. And so that's the strongest form of protection that can be given to that type of constitutional right. I don't know if that answers your question.
Right?
Oh, yeah, in that context, then the work is all done at the first step. Are you within or without the zone of the right? But most rights have limitations, and so you have to decide which limitations are in or out. And then I actually think that the most work is done, and where I have seen, frankly, litigating these cases in the United States, most of the work is done in the evidentiary question: have you, the government, demonstrated that your policy is necessary to advance whatever this permitted reason is? That's where the rubber meets the road. That's where I think the rubber should meet the road. And that sort of evidentiary, discrete, factual question is more appropriate to the judicial competence than the free-willing moral question: which of these values do I think is weightier?
Well, thank you very much for Professor Keown for being here with us, Professor Barclay, for this panel and all the panels and presentations and questions for today. We have arrived to the end of the first day of this conference.